Hello and welcome to our discussion of the right to privacy and the case called Griswold versus Connecticut. We need to talk a bit about the concept of substantive due process as it relates to rights not specifically mentioned in the Constitution, and discuss a bit about how due process, the concept of due process might help us to define those rights and give them some form and legitimacy, and how Supreme Court justices have interpreted other parts of the Constitution to include a right to privacy. So let's get started. So where do we find this right to privacy? Specifically, it is nowhere mentioned in the Constitution. But one might say that one has a right to privacy in their opinions, and also a right to privacy in keeping their associations private. That's the whole point of the idea of private association, union, and combination. And so in the cases on free speech rights of individuals brought before the House Un-American Activities Committee, the court interpreted some of the speech rights of individuals as private. The Third Amendment also suggests a right of privacy that exists in the home, a right to be free from quartering soldiers without consent. The Fourth Amendment also speaks to privacy in terms of search and seizure, that you have privacy in your person and your house, your papers and effects. And that privacy extends to unreasonable freedom from unreasonable searches and seizures, and also seizures that should have been preceded by a warrant but were not. The Fifth Amendment suggests a right of privacy in terms of your right to be informed of rights that you have before interacting with the state. For example, a right to remain silent. Also, the Ninth Amendment specifically says that the list of rights in the Bill of Rights should not be construed to mean that there are no other ones. And if we think back to an earlier section on due process, we know that the Supreme Court has, in fact, found rights not listed in the Constitution to be part of the meaning of due process in the 14th. Duncan versus Louisiana, a general right to trial. Also, the Scottsboro Boys case suggests a general right to an attorney, but not specifically the one mentioned in the Sixth Amendment, just a general right where due process requires it. Also, the court has found the existence of other rights to be part of the meaning of due process in the 14th. And so one wonders a little bit about what purpose the Ninth Amendment serves if we can interpret the meaning of due process so broadly to include other rights not listed. And there it is, the 14th Amendment substantive due process guarantee, the general guarantee of liberty, not simply a procedural form of due process, but a substantive one. So the members of the court have found a right to privacy in all of these different areas. And I think those who have argued against a right to privacy, and early in my career I was one of those people, those people tend to want their privacy when they want it, and then not to see it where it doesn't really concern them. So my thoughts and ideas about privacy have changed significantly over the years, and maybe we can talk a little bit about where I think that right to privacy is found. So here are some foundations. So in Lochner versus New York, the Supreme Court interprets the right to contract to be part of the meaning of the word due process in the 14th Amendment. In other words, you have a substantive right to contract that exists as part of the meaning of due process, and you don't have to point to any particular part of the Constitution to find it. And this was part of an era in which the Supreme Court was engaged in something called economic substantive due process jurisprudence. They were finding a right to a substantive right to due process in such things as the right to contract, and those things trumped other powers of the state to maintain order. In a dissent in a case called Olmsted versus United States, Justice Brandeis claimed that wiretapping was wrong, that it violated the privacy of individuals, and that privacy had to be respected. In a case called Meyer versus Nebraska, the court was considering a ban on across-the-board ban on the teaching of the German language in Nebraska as part of the public school curriculum. And in considering whether there was a right to have your child educated in the German language, to teach the German language, the court considered a lot of other things, and it invoked as the text says, it invoked a substantive due process approach to strike down the law that forbade schools to teach German and other foreign languages to children below the 8th grade. Here's what the court had to say about the liberty that is invoked in the 14th Amendment, and how it protects more than simply a right to enter into a contract. Here's what it says. The right of the individual to engage in any of the common occupations of life, to acquire useful knowledge, to marry, to establish a home and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. This is what due process in the 14th Amendment means. Now, let's look at these a little bit. So, the court says in 1923 that due process involves the right to engage in any of the common occupations of life. Well, that seems to run contrary to the court's decision in the slaughterhouse cases that due process did not mean the right to engage in an occupation without governmental interference. The right to acquire useful knowledge. The court said that education and other ways of acquiring knowledge are part of the meaning of due process. To worship God according to the dictates of conscience, well, we can point to something specifically in the Bill of Rights that that protects that. And generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness. Well, these are things that are not explicitly stated. So we see right off the bat that the Supreme Court is finding things as part of the meaning of due process in the 14th that aren't specifically mentioned in the text of the Constitution. In Mapp versus Ohio, a case we should have read earlier in the course, the court invokes the exclusionary rule to say that when police violate your right to privacy, either in your person or, as in the case of Mapp, in her home, that evidence illegally gathered may be excluded from trial for the purpose of gaining a conviction. And then that brings us to Griswold versus Connecticut. Now, this case is very different from the others that we've looked at up until this point. Those cases involved economic rights and education and criminal rights. Griswold involves the right to procreate. In particular, it involves a statute in Connecticut that made it illegal to distribute condoms and other contraceptives to married couples. Estelle Griswold calls up the police and says, "Please come down to the clinic I've established. I'm distributing contraceptives to married couples in violation of your law." So this is a test case, really. She wanted to be arrested so that the Supreme Court could consider whether marital privacy and procreative privacy is part of the meaning of due process in the 14th. So the question is, does the Due Process Clause of the 14th Amendment guarantee a right to privacy in marital relations? Supreme Court says yes, 7-2, and Douglas writes the majority opinion, but he doesn't take, and this is important, he does not take the substantive due process route. He says the law is invalid because the case concerns a relationship that lies within a zone of privacy that's created by a number of other fundamental constitutional guarantees. And he uses the word penumbra. Now, he wants to stand the right to privacy on its own 2 feet. And he says that it can be extrapolated, an actual right to privacy can be extrapolated from other rights that are mentioned in the Constitution. These rights have penumbras. Now, penumbras, he says, are emanations, areas in which we're not certain whether a thing is part of one thing or part of the other. I'll give you an example. If you go out and look at the moon on a cloudy night, you cannot see a clear demarcation between where the moon starts and where the sky ends. There's this sort of hazy area around the moon that sort of blends into the sky behind it. And that's called a penumbra. Justice Douglas says that the penumbra, that the right of privacy exists in that sort of penumbra found in various rights in the Constitution. You should look closely at what he says those rights are. Other members of the court dissent, and they say, for example, they say, well, this law is invalid, and we think it's a particularly silly law because, but not because of a right to privacy, but because of substantive due process guarantee. Justice Harlan makes that argument. Justice Brennan signs on to his dissent. Now, after Griswold, we get a number of cases, Katz versus United States, in which the Supreme Court says that individuals have a right to privacy where they create it. So the right to privacy attaches to the individual and not to the place. And the court says that using wiretaps on someone who's attempting to keep his conversation private, using wiretaps without a warrant, is unconstitutional. In Stanley versus Georgia, the court identifies privacy in one's home. That's the case related to pornography, having pornography in the home. And here, substantive due process was key to making these decisions, and the court uses rational basis to make the decisions that a right to privacy exists in the home and in other areas of life. Now, the follow-up to Griswold was a case in which the Supreme Court said that a state does not have an interest in banning the distribution of condoms and other contraceptives to unmarried people. So the court extends the Griswold decision out from just married couples to also include unmarried couples, because the court says the decision to bring a child into the world, to procreate, can be made outside of the decision to marry, and that it is a deeply personal decision in which the state does not have a right to meddle. So that is our introduction to privacy and to Griswold versus Connecticut, and we'll continue on through this chapter.